Here's something that catches a lot of Canadian retirees completely off guard. If you were to become ill tomorrow, not permanently, just temporarily incapacitated, your spouse, your children, your closest family members would have zero legal authority to touch your bank account. They couldn't pay your mortgage, they couldn't make sure your CPP and OAS payments kept flowing into the right account, they couldn't handle a single transaction on your behalf. Not without going to court first, and that court process, called guardianship or trusteeship depending on your province, can take months and cost thousands of dollars. While your family is scrambling through that process, your bills pile up, your pension income sits untouched, and your financial life essentially freezes. This is the reality for Canadians who reach a medical crisis without a power of attorney in place, and it happens far more often than most people realize. Today we're going to talk about what a power of attorney actually is, what it covers, what happens if you don't have one, how it connects to your CRA account and government benefits, and the one critical thing that a power of attorney cannot do, which is something many people get confused about. I'll also cover how to get one done affordably, and in some cases for free. This isn't a topic that only applies to people who are elderly or in poor health. If you're 60, 70, or anywhere in between and you haven't set this up yet, this video is for you. And later on, I'll walk through what a family discovered the hard way when a stroke changed everything before the paperwork was in order. Let's start with what a power of attorney for finances actually does. When you sign a power of attorney for property, that's the financial version, you are giving someone you trust the legal authority to manage your money and your assets on your behalf. That person is called your attorney, but they don't have to be a lawyer. They can be your spouse, your adult child, a trusted friend, or a professional. What matters is that you trust them completely because the authority you're granting them is broad. Under a valid power of attorney, your chosen attorney can manage your bank accounts, pay your bills, sign checks, make withdrawals from your RRIF or investment accounts, handle real estate transactions, and ensure your CPP, OAS, and other government income keeps flowing to the right place. Government benefit forms, including the direct deposit forms for CPP and OAS, have specific provisions for a legal representative acting under a power of attorney to sign on your behalf. That means if your banking details ever need to change, your attorney can handle it without you needing to appear in person. And here's what makes this so important. The moment you lose mental capacity, whether from a stroke, dementia, an accident, or a medical crisis, anyone without this document has no legal standing. Your spouse of 40 years cannot sign a check from your personal account. Your daughter cannot call the bank on your behalf. Without the legal authority of a power of attorney, everything stalls. Now, there's something crucial about the specific type of power of attorney you need. A general power of attorney is automatically canceled the moment you become mentally incapable, which means it fails you at exactly the moment you need it most. What you need instead is called an enduring or continuing power of attorney, depending on your province. This version remains valid even after you lose capacity. It was designed precisely for situations where someone can no longer manage their own affairs. So when you're setting this up, make sure the word enduring or continuing appears in the document, and make sure it meets the legal requirements of your specific province. Think about what it means to have this in place. You go into the hospital for a serious procedure, you're recovering but not fully coherent for a few weeks. Your attorney steps in, pays your property taxes, ensures your pension payments are directed correctly, and keeps everything running. When you come home, your financial life is exactly as you left it. No court involvement, no fees, no family conflict, just a document you signed ahead of time, doing exactly what you intended. Now, let me tell you about a situation that shows what happens when this isn't in place. Jim and Carol had been married for 35 years. Jim handled most of the finances and the banking, the investments, the income tax. Carol managed the household. When Jim suffered a sudden stroke at 68 and was hospitalized for several weeks, Carol found herself unable to access their joint accounts, unable to make changes to his pension direct deposit, and unable to deal with any of the financial institutions in his name alone. She had to hire a lawyer immediately, gather medical documentation, file court applications, and wait. The process took nearly 4 months and cost the family close to $8,000 in legal and court fees, money taken directly from their retirement savings. All of it would have been avoided with one document signed years earlier. There is another piece to this that connects directly to your dealings with the Canada Revenue Agency, and it's something a lot of people don't realize is a separate step entirely. A power of attorney for finances gives your attorney broad authority over your money and assets, but the CRA operates under its own rules. Even if someone is your attorney under a provincial power of attorney, they still need separate authorization to deal with the CRA on your behalf, to access your tax information, discuss your account, file returns, or apply for benefits. This is done through what used to be called Form T 1013, which authorizes a representative to deal with your CRA file. Today, the CRA prefers this to be done online through the My Account portal, but the paper form is still accepted. The important point is this: if you want your attorney to be able to fully manage your affairs, including your tax situation, you need both documents. The provincial power of attorney handles your financial institutions, property, and pension income. The CRA authorization handles your tax file. They work together, but they are not the same thing. Getting both in order at the same time is simply smart planning, and it takes very little extra effort. Now, before I get to the question of cost, because I know that's on a lot of people's minds, I want to address the single most common misconception I come across on this topic, and it's one that could genuinely lead people to make a costly mistake. Many seniors believe that having a power of attorney means they're covered for everything, including what happens after they pass away. They assume their attorney can wrap up their estate, transfer their assets to their children, and handle the distribution of everything they've built over a lifetime. That's not how it works, and this is the part worth staying for. By the way, if this kind of retirement planning information is helpful to you, consider subscribing to Canadian Retirement Benefits. We cover CPP, OAS, GIS, estate planning connections, and everything that affects your retirement income, seen in plain language every week. It only takes a moment, and it could make a real difference. Here's the truth about a power of attorney. It ends the moment you pass away. The legal authority your attorney had while you were alive disappears at the moment of your death. From that point forward, your estate is governed by an entirely different document, your will. A will is what determines who receives your money, your property, your belongings, and everything else you leave behind. If you pass away without a will, which is called dying intestate, the government of your province steps in and distributes your estate according to a fixed set of rules. Those rules don't care about your wishes. They don't know that you wanted your vacation property to go to your grandchildren, or that you wanted a particular child to receive more because they were your primary caregiver. The rules are mechanical, and they often produce outcomes that families describe as deeply unfair. These are two separate documents for two separate situations. One covers incapacity during your lifetime, the other covers what happens after you're gone. You genuinely need both. Now let's talk about the cost, because I don't want anything to stand between you and having these documents done. A simple will and a continuing power of attorney, prepared by a lawyer, typically cost somewhere in the range of a few $100s when done together. Some firms offer flat fee estate packages that include both documents for under $800. That may sound like a lot if you're on a fixed income, but compare it to the thousands that a court-ordered guardianship would cost your family, and it becomes clear which option is the real financial burden. And if cost is genuinely a concern, there are free options. Most provinces have community legal clinics that provide estate planning services at no charge to seniors on low incomes. Law school clinics also frequently offer free wills and powers of attorney for qualifying individuals. In Ontario, for instance, the government will actually mail you a free power of attorney kit on request, and there are guided online tools through government websites to help you complete it. Other provinces have similar resources, so if hiring a lawyer isn't possible right now, free help is available and it's worth seeking out. The key is not to let cost or time or the assumption that this can wait be the reason it doesn't get done. Let me bring everything together. A continuing power of attorney for finances is one of the most important documents a Canadian senior can have. It ensures that if you ever lose the ability to manage your own affairs, temporarily or permanently, someone you chose and trust can step in immediately to keep your financial life running. Your CPP and OAS keep flowing, your bills get paid, your accounts stay active, and your family is spared the months-long, expensive process of going to court just to help you. Pair that with a CRA representative authorization so your attorney can deal with your tax file as well. And pair both of those with a will so that when the time comes, your estate goes where you actually want it to go, not where provincial rules send it. You've spent your working life building financial security for yourself and your family. A power of attorney is how you protect all of that in the years ahead. It's a small step with an enormous impact, and the best time to take it is before you need it. If you found this helpful and want to stay informed about CPP, OAS, GIS, and other topics that matter to Canadian retirees, consider subscribing to Canadian Retirement Benefits. Thank you for watching, and take care. Retiree.